Hey, welcome to today's video. I'm Richard Chapo. I'm an attorney in San Diego, California, and I represent online businesses. I've been doing so for the past 20 years. So today we are looking at a recent Supreme Court decision from March 2019 that deals with a unique and interesting copyright question that's been floating around for decades. And the court has finally arrived at a decision, even though I tend to think it's the wrong decision. But there you go. So the name of the case is not Supreme Court Knives Copyright Holders. Instead, it's Fourth Estate Public Benefit Corp. versus WallStreet.com LLC. And the case deals with a very simple, well, seemingly simple question. And that is, if you are a copyright holder in the United States and somebody allegedly infringes on your copyright, when can you sue them? So when can you bring a copyright infringement lawsuit against them? Now, at first glance, particularly given our litigious society, you might be thinking, whenever. Sue them now, sue them tomorrow, who cares? But that's not the way the copyright system works in the United States, of course. So in the United States, we have generally two types of copyrights. One is common law copyright, and the second is a registered copyright. Now, common law copyright is the copyright that's created once you finish a work. So let's say I draft the Great American Novel. It's an 800-page opus involving everything from, I don't know, a torrid romance to vampires, maybe some aliens, and let's throw a couple car chases in there. I start sending it off to agents. Okay, well, I own the common law copyright to that book and that text. And obviously it's whether it's good or not. But I do own the copyright to that, the common law copyright. Now I send it off to the agents, and of course, most of the agents send back a letter, please never contact us again. However, one agent reads it and thinks, oh my God, this is the greatest novel I've ever read. And that person is so impressed that they abscond with the book. They basically Photoshop off my name and add their name, and they start trying to sell it to various book publishers. So at that point, can I sue that agent for copyright infringement? And you might be surprised to learn the answer is no, I cannot. Because under the US system, you cannot file a copyright infringement lawsuit based on common law copyright. Instead, you first have to go register the copyright. And so unless I go to the Copyright Office and register my copyright with them, I can't do anything. How bizarre is that? But, well, welcome to copyright law. So this has raised an interesting question that copyright lawyers and internet lawyers and judges and legal scholars have thrown around for a while. And the question is simply this. So do I have the right to go file my infringement lawsuit once I submit my application to the Copyright Office? Or do I have to wait for them to approve it? Seems pretty simple, right? Now, at first glance, you might be thinking, common sense says, you should have to wait for approval. Because what if the complaint or what if the application is rejected? And that makes sense. If you've never dealt with the Copyright Office. If you have dealt with the Copyright Office, here's what you're going to know. They rubber stamp the applications unless there's just a blatantly obvious, infringement on another copyright. Like, say I copy, the J.K. Rowling, one of the J.K. Rowling Harry Potter novels, word for word, including listing her name on the cover. They're almost always going to rubber stamp it. It's a one-page application. There's nothing sophisticated going on here. And their view is basically, if it's a close call, well, that's a matter for the courts to decide. I've been doing this for 20 years. I've never had a copyright application rejected. I've never even had one questioned. I mean, it's just the reality of life is that, they're going to approve it. They're almost always going to approve it. And now there's another aspect of this process that you need to know about, which is the Copyright Office is not quick. So when you submit your registration application, you can expect to wait 6 months, maybe longer, before they get around to approving your copyright. And so during that 6 months, that agent who absconded with my novel is theoretically making money off of it. Now you may be saying, well, you'll eventually get the money back in the infringement lawsuit. Maybe. Or maybe the agent is hiding money, or, whatever. If they've just absconded with my novel, they probably have a plan for what they're going to do with the money, because they know eventually something's going to happen. And so it doesn't make a lot of sense as to, why one would argue that the approval is necessary. Now let's look at it the other way. What if we said, okay, you can file the infringement lawsuit once you submit your application to the Copyright Office? Okay, well, who is that going to hurt? The infringer? Not really, because you're going to sue them one way or the other. I mean, if you're submitting the registration application, that lawsuit's coming now or later. And if they haven't infringed, well, it doesn't really matter when you file your lawsuit, does it? They're going to win. And conversely, if they have infringed, why would we give them an extra 6 months? That doesn't make any sense. However you feel about copyright, let's assume you're the person who wrote that novel. Should they get that extra 6 months? I don't think so. Now, what if you file your application and the Copyright Office, on a blue moon, rejects it? Okay, well, doesn't that create a huge mess? And the answer is no, not at all. Because what would happen then is the defendant would file a motion to dismiss with the court, and your lawsuit would be dismissed because you would not have a registered copyright. And that's it. It would be that simple. So what we have here, and you can probably guess already what the Supreme Court ruled, is the Supreme Court held that you have to wait for approval. And what it reflects is really a court that doesn't understand the practical aspects of the Copyright Office and copyright, or doesn't care. And we have a majority of justices now who tend to do strict readings of the legislative code. People all get worked up about the Constitution, but it's often almost more important, how they're interpreting the code. And in this situation, they're interpreting it in the strictest manner possible, and applying almost no practical knowledge to the situation, no practical day-to-day understanding of what really happens in the real world to their ruling. And so it's a fairly bizarre decision, to be quite honest. To give you an idea of just kind of how bizarre, let's say that you are a copyright holder outside of the United States. So you live in a beautiful place like Bali. You write that great Bali novel, and you submit it to an agent, 5 or 6 agents in the United States. And, 5 of the agents send you the cease and desist, don't ever get in touch with us again. But that 6th agent thinks it's the greatest thing ever, and they Photoshop your name off and put their name on and start trying to sell it to book publishers. Well, because you are based outside of the United States, you can come into the U.S. and file an infringement lawsuit against that agent immediately. You don't even have to register with the Copyright Office. So arguably, copyright owners who are located outside of the United States are put in a better situation in our legal system than the ones that are in the country. So how that works, I'm not entirely sure, but hey, welcome to copyright law. So what is the lesson about all this? Whatever you feel, whichever side you come down on, maybe you think you should have to wait for approval, maybe you don't. It doesn't really matter. The lesson from this is, if you're creating a work that has some value, that you value, then you need to go register it. And you want to register it within that first 90 days, because then you're going to get statutory damages if somebody infringes on. Now, when you're registering it, you have to consider the content itself. It's $55 or $35, depending on, the type of registration that you submit or type of application that you submit. So we're not talking big money, but obviously if you're pumping out, 50 blog posts a month, well, you're obviously going to have to think about, are any of these really that valuable that I want to go through this process? But with more sophisticated content, maybe, courses or something of that sort, you may well want to go ahead and copyright them, because it's going to give you a certain benefit that you can pursue in infringement lawsuits, and you won't have to worry about the question about when can you actually file an infringement based on the timing of the registration. It just becomes a non-issue. So that would be the lesson here. So Supreme Court knives copyright holders, the Fourth Estate Public Benefit Corp versus WallStreet.com LLC. Personally, I think it's a poor decision, but we at least have an answer to the decades-old question of when can you actually file an infringement lawsuit? And the answer is only once the Copyright Office has approved your registration. And so there you have it. Now, one final caveat to this, which may well scupper the entire argument in your mind. There is an expedited registration process for copyrights. And I believe the fee these days is $800. And so if I saw that agent run off with my book, I could go submit an expedited registration. I think it takes about a week, and pay $800 to get that taken care of. And so there you go. Now, certainly, with the movie industry and the music industry, that's not a big issue. But when you're talking about writers or artists or photographers or what have you, if they're have to go pay $800 every time someone's stealing their content, well, then that adds up pretty quickly and really becomes a burden and a deterrent from enforcing their copyright. But that is something we always have to keep in mind. So anyways, the lesson still remains the same. If you create a work that you value, something that you think is going to have intrinsic value, then you want to go ahead and copyright it immediately. File with the registration with the Copyright Office. It's simple. You can even do it online now. Not a big problem. If you need help, let me know. I'll be happy to help. But get that done in the first 90 days and you'll be able to get statutory damages. So that's it for today's video. If you have questions or comments, feel free to post them below. If you enjoyed the video, consider giving us a thumbs up. If not, I feel shame. And we'll obviously be publishing all kinds of different videos on internet law topics that'll be of interest to people who own online businesses. So feel free to subscribe to the channel. So thanks for watching. Have yourself a good one.